everybody. I'm John Giardinelli. I'm Association Counsel. I'm with the Tyler Law Firm, and we're going to do today's rant on a couple of topics. As most of you know, under the new MLS rules, you are required whenever you access a property listed in the multiple listing service per the NAR settlement and the new MLS rules, you are required to have a written agreement with your buyer before you commence touring. There's a $2,500 fine if you access a property that's listed in the MLS and you do not have a written agreement. But of course, it doesn't cover every property. It doesn't cover every type of property. And frankly, it only covers realtors and MLS members. On January the 1st, however, a new law will go into effect, which is a major change in the way all real estate licensees are going to handle things. AB 2992, which we've been talking about for a couple of months, has been signed into law by the governor and will amend both the Business and Professions Code as well as the Civil Code. Because it amends the Business and Professions Code, it means it will be applicable to all licensees, not just MLS and or realtors. So I want to kind of go over it, talk about it a little bit, because since it could lead to a Department of Real Estate violation against your license, as well as civil violations, as well as MLS rule violations, as well as possibly preventing you from being paid a commission that you've earned. I think it's going to be a critical law that goes into effect, like I said, on January the 1st, 2025. So it is not the law today. Okay, number one, it applies to all licensees. Doesn't matter whether you're a member of the multiple listing service, whether you do vacant land, doesn't matter. Every licensee will be required to have a written representation agreement to represent a buyer. Number two, other than rental leasing properties, so property managers are excluded from most of the law. You will be required to have a written license for residential 1 to 4, multi-tenant, commercial, industrial, vacant land, even ground leases with improvements on them. So that's something to consider for everyone, even the people in your office that may not do the standard residential 1 to 4. It will be 90 days. A contract with a buyer cannot exceed 90 days. And 90 days is going to be defined by the Department of Real Estate and their upcoming regulations as either the date of or the date after the day that the agreement is signed for a 90-day period. And if the 90th day falls on a Saturday, a Sunday, or a holiday, it doesn't matter. It's still expired. You can extend it, but you have to extend it with a written agreement of some sort. It could be an addendum, but you cannot put in the buyer representation agreement any automatic renewals. They will not be considered valid. So those are commonly referred to as evergreen clauses, and evergreen clauses will not be allowed. One important fact, and the law is written a little differently than the MLS rule. The law says that you must have a written agreement signed with the buyer, quote unquote, as soon as practicable, but no later than when you write up an offer. So what is as soon as practicable? The regulation, which is undergoing the usual bureaucratic thing and probably won't be out till probably around February, March, maybe even April. Could be later, depends on what's going on at the department. But as soon as practicable what will happen is the regulation will say that the burden will be on the real estate professional, the licensee, to establish why they could not get a written agreement executed before touring. Touring, which is what the MLS rule and the NAR antitrust settlement agreement says. Touring is going to mean in the regulation physically or virtually entering upon a property. So if you send out information, not going to need a written agreement. If you do anything else relative to just providing information, you aren't going to need a written agreement. But the minute you start virtually entering and or physically entering property, open house, whatever it might be, a lockbox property, once you start doing that, you must have a written agreement, and the burden will be on you to show why you couldn't get one before you started doing that. So if the seller, excuse me, if the buyer isn't willing to sign, or some other issue comes up where the circumstances dictate that you can't get a written agreement, you're going to have to document your file in case something comes up. You're going to have to prove why you couldn't get a written agreement. It's not going to be automatic. Burden's not going to be on someone else. It's going to be on the licensee. That's a really big deal. So for those of you that are in the habit now of getting a BRBC or some other buyer representation agreement signed before you start work, well, that's a good thing. This is not going to be a big deal for you, but you are going to have your files documented, because you're going to want to be able to establish on those rare occasions when you can't get an agreement why you can't do that. You're going to have to make sure that your buyers understand that. This is a major change in the law. This is, and again, in some cases, you're going to be doing this with people you don't really know, you've just met, or have not had a real relationship with. If you do not have a written agreement, any verbal agreement is void and unenforceable. So if I say to you, show me some properties, if I find a property that I like, I'll hire you, I'll pay you a commission, and then we get to that point and you've shown me a bunch of property, you've driven around with me, and you don't have a written agreement, you're not going to get paid. Okay, I don't have to pay you. I can go to somebody else. So all this procuring cause stuff is no longer going to be important. It's going to be based on a written agreement. Oral agreements will be voidable and not enforceable. As I mentioned, you cannot automatically renew these agreements. So there's going to be you can use an addendum. I'm guessing you can probably use an email, but again, you're going to have to make sure that you talk to your lawyer or get some help. Use the right form to make sure that if let's say, for example, we're on the 80th day, we've been showing you some property, and you realize, this contract expires in 10 days. Are you willing to extend it? And then what period of time? 30 days, 60 days, another 90, but it can never go beyond 90 days, okay? And the agreement, some of you are using a BRBC, the CAR form. Some are using company forms. You need to make sure that the company forms contains four elements. Number one, it has to define what compensation is going to be by either a percentage or a dollar figure, and except under an extremely rare set of circumstances, can you make more than whatever your contract says. Number two, has to define the services. Okay. Number three, it has to provide for a termination date. And number four, it has to provide how the money that you earn is to be paid. And the reason I recommend using the BRBC is because CAR has taken into consideration all of these requirements. It defines compensation, it defines services, it has a termination date, and it indicates that under most circumstances, the money will be paid at closing through escrow by proceeds. All right, also a couple of other things. The agreement must contain the standard statement of negotiability of commissions. You will be required to have an agency disclosure form. The BRBC is bundled with an agency disclosure form. Going to be two updates in December. Number one, they're going to update the agency disclosure, the AD form, to have all of this information in there about the new laws. And they're also going to start bundling an AD with that a PSAR form, which is the short-term 3 properties or less, 30 days or less. And so they're going to start bundling the AD form with that. Like I said, there's going to be a few very minor exceptions. Some are dealing with corporations and the amount of time they can enter into contracts. One of the exceptions deals with the LLCs. So we're going to have a newsletter that's going to be disseminated through the board, and we'll get you all the information you're going to need. But again, you're going to have to do it. And if you fail to do it, we're going to have some real problems. And so you want to make sure that you stay on top of this. And if you have questions, jot them down, get them to Lori, and we'll do our best at a brown bag or a legal panel or in some upcoming program to get you the information that you need. One other issue I wanted to briefly talk about is the settlement itself. We're getting real close to the end of the trail here. I'm recording this on November 15th, 2024, and on November 26th, 2024, the judge that has been hearing these class actions will determine if the settlement, which has been entered into by NAR and a number of other litigants, is going to be approved. If it is approved, then all cases all over the country will be dismissed, realtors will be off the hook, and NAR will have agreed over the next 3 years to pay out about $418 million. And the other defendants will also pay out whatever they've settled with. There have been some objections to the settlement. Most of the objections are procedural in nature, not really something that you should be concerned with. Some of the objections are because the lawyers that are not principally involved with the Kansas City Sitzer case may not get as much money as they want. But assuming the settlement is approved, it will resolve virtually all of these seller-initiated class actions, including the 4 that are pending here in California. What are the objections? Well, substantively, they're claiming a couple of things that realtors are allegedly still doing despite the settlement. I haven't seen a widespread situation where realtors are not trying at least to comply. There is a lot of confusion. There's no doubt about that. But the confusion as we move on down the road is going to become less and less issues relating to open houses, issues relating to unrepresented buyers, concessions, and those kinds of things are going to become more commonplace, and you'll become more comfortable with them. A couple of tips to make sure that you don't get in trouble. Make sure you do not steer clients to commission related homes. In some cases, sellers are offering compensation through concessions, but some are not, about 50-50. That doesn't mean that they won't pay a commission. It just means they're not offering it as part of the package in the MLS. But it's critically important that you not steer people away from homes where there is no offer of compensation or concession. Because if you do that, you could be accused of steering, and that's one of the objections that seems to be coming up. Another objection is that realtors continue to mislead buyers and sellers on commission issues and on showing property and the likelihood that property will be shown. And so you need to be really, really careful. The Department of Real Estate is monitoring very carefully complaints about people who steer and or who mislead. Um, the claim is that realtors are doing everything they can to maintain minimum commissions. And I frankly don't understand that argument, because of course you're trying to be paid. There's nothing wrong with being paid. What's wrong is misleading people, but there seems to be this sense out there by the Consumer Federation and others that maybe you shouldn't be paid very much. Statistically, commissions are holding fairly steady, whatever that means. They're obviously always negotiable, but there hasn't been a big drop, at least nationally. Some people are refusing listings if they don't offer concessions. I think that's a mistake, because again, if you take a listing, put it in the MLS and market it properly, and an offer comes in where they're asking for concessions through the payment of buyer side compensation, your seller will then have the right to decline it, counter it, whatever they want to do. So be very careful about that. We're also seeing a lot of misunderstandings about open houses. There is no obligation to have a written agreement to enter into an open house. So I don't have to have a BRBC, and you don't have a duty to police it. That's an MLS issue. The MLS has been charged primarily, and professional standards departments at the associations, with enforcing these rules through the code of ethics and or through the MLS citation policies. And of course, the courts may step in at some juncture. And frankly, next year, when the Department of Real Estate gets involved, they may step in. But for right now, be careful about open houses. There is no form that is required to be signed. There are suggested forms that the California Association of Realtors produces for open houses. If you can get the potential buyer to sign them, they're very simple, doesn't create any kind of a contractual relationship. It just lets them know that you don't represent them, that you only represent the seller. If in fact the person looking at the property decides that they want to make an offer, they will then, and use you as the listing agent, then that's when a written agreement of some sort needs to be signed. We're seeing a lot of issues come up relative to unrepresented buyers, and I just wrote a newsletter which is, I believe, gone out, that will do a pretty deep dive on unrepresented buyers. So again, there's a lot of confusion. I don't think anybody, not too many agents are acting inappropriately. Some, you're always going to have that. That's why we have a professional standards department, because there's always going to be ethical people, unethical people doing unethical things, and we try to catch them whenever we can. So that's what's going on right now. We're going to do more rants in the future, but for right now, I just wanted to give you a taste of some of these issues. I believe that on November 26th, the hearing will be conducted, and Judge Bao, who is overseeing all of this, will approve the settlement. He may not do it from the bench. He may do it via a written opinion. Because the 26th falls just below Thanksgiving, I suspect that he would wait until the next week or so to issue a written opinion. But I believe that he is going to approve the settlement, and will then be on the backside of all this litigation. And at that point in time, we'll do some intense training on some of these issues. All right, well, that's it for today's rant. Hopefully you found it helpful in some way. Again, start using buyer representation forms if you haven't already, because it's going to be state law. It isn't a MLS issue any longer, and get yourself in a lot of trouble if you don't use it properly.